What happens when an irrevocable family trust holds over $2 million of marital assets but excludes one spouse entirely in a divorce? The Utah Supreme Court faced that exact question in the Dahl case. Here's the $2 million problem. If the trust was truly irrevocable, wife couldn't withdraw any marital assets under Utah law. And once divorced, she'd no longer qualify as settlor's wife under beneficiary definition, meaning she'd lose any claim to $2 million in previously marital assets. But buried in Section 5.5 of that trust agreement was one clause with potentially contradictory language that would take the Utah Supreme Court to unravel the impact on the trust and in the divorce. I'm Kelly Lise Murray, and this is Wealth Litigated, delivering all the drama of true crime without the blood. We break down actual court cases that impact your professional practice and your client's wealth outcomes. In episode 107, Divorce Busting Irrevocable Trusts, we examine how one clause impacted the revocability of an irrevocable family trust, explore choice of law with other critical legal issues that put $2 million of marital assets on the line, and analyze the Utah Supreme Court reasoning in this high-stakes divorce. Join us to see how it litigated and subscribe so you don't miss an episode.
When fortunes collide with courtrooms, wealth managers, financial advisors, accountants, fiduciaries, and lawyers need real answers. Welcome to Wealth Litigated, where Professor Kelly Lise Murray, J.D., lawyer, legal scholar, and retired Vanderbilt Law faculty, analyzes actual courtroom wins and losses in asset protection to deliver actionable insights that optimize your client's wealth outcomes. From explosive family feuds over fortunes to sophisticated financial fraud, each week we explore what worked to protect wealth and what exactly went wrong, so you get it right. And now, here's your host, Professor Kelly Lise Murray.
Let's gavel in. In the Dahl divorce, if the irrevocable family trust remained irrevocable, the wife would lose her marital interest in over $2 million of formerly marital assets. But the ultimate takeaway from Dahl is this: how can estate planning trust structure shield or fail to shield marital assets from divorce property division? In Dahl, the Utah Supreme Court had to decide 4 critical legal issues, 1 procedural, 3 substantive, in order for the wife to prevail on her theory that the trust was revocable and that the marital assets transferred to the trust should be divided in this divorce. She needs to run the table on all 4 of these issues. The first, is an irrevocable trust a necessary party? We know it's a separate entity, but in a divorce, must the irrevocable trust be joined as a party? Here, it would have been the wife joining the trust as a defendant. And what are the consequences in the divorce itself for failing to join an irrevocable trust as a necessary party? The second issue is choice of law. The irrevocable family trust in the Dahl case specified a different state for its choice of law. The divorce itself occurred in Utah, but the irrevocable family trust stated that it was to be governed and construed by Nevada law. If Nevada law applied, this trust would remain irrevocable and the wife would lose that $2 million interest in formerly marital assets. The third issue is the trust revocable. The trust was labeled irrevocable, internally described as irrevocable, but there's one clause that could possibly change everything. And then the fourth issue, whether the wife was also a settlor. Settlor is a legal term for the creator or the grantor of the trust. In the facts of the Dahl case, only one spouse was named as the settlor. That was the husband. But husband and wife each contributed marital assets and separate assets to this trust. Does that make a difference? We'll see how the Utah Supreme Court ruled. In order to prevail, the wife needs to run the table on all 4 of those issues. She needs legal help from the Utah Supreme Court because she and her lawyers failed to join the irrevocable trust as a necessary party. She needs Utah law to apply, not Nevada, otherwise this trust is irrevocable. Then, under revocability, she needs one clause to be interpreted favorably for revocation. And then finally, as a contributor of assets, does that make the wife a settlor of this trust, even though she never signed the trust, she never saw the trust documents, and was unaware of the specific terms. These are some of the trust facts relevant, and some are material to the Utah Supreme Court's resolution of this case. Husband was the only settlor. He was the one who created the trust. He's named as the sole settlor, simply the creator of the trust. He contributes his share of marital assets to the trust, and he gets the wife to do the same thing. The wife contributed about $2 million of her marital interest, so approximately $4 million in marital assets. She contributes $2 million of her marital interest, including the marital house, by warranty deed. The trustee is the husband's brother. Next, the choice of law specified in the trust is Nevada. Now, they're getting divorced in Utah. Nevada was chosen because of its statutes that are more favorable to keeping irrevocable trusts irrevocable. The beneficiaries, the husband is named as a beneficiary during his lifetime. So his name, beneficiary during his lifetime. Additional beneficiaries include the children of this marriage and charitable organizations. But there's a beneficiary who is identified by a definition, not by name. An additional beneficiary is the wife of settlor. Based on how this trust was written, it meant that the husband's wife as a status is a beneficiary. Now, what happens if husband and wife divorce? His current wife would no longer have that status. She would no longer be a beneficiary. So why even bother to do this? It makes the wife, in this case, a temporary beneficiary. She's only beneficiary so long as she has the status of his wife. Why even do that? Because she contributed over $2 million of her interest in marital assets. And in order for her to get the benefit of that bargain, they had to make her a beneficiary. But by phrasing it this way, excluding her name and making the beneficiary the settlor's wife, whoever is the settlor's wife now or in the future after a divorce, it changes because it's not tied to a person's name. Now, just a quick sidebar. You can do this the other way and have the same result. You can name a beneficiary as settlor's spouse and name the spouse, but then redefine it as that spouse is a beneficiary so long as they remain married to the settlor. It's the same result. Here, the wife was not even named. She's simply the beneficiary temporarily so long as she is the husband's wife because he's named as the settlor. We have a trust that is titled irrevocable. It's also described internally as irrevocable. And we have the other spouse who, after divorce, will no longer be a beneficiary in the divorce proceedings, trying to get this trust reframed by the courts as revocable. Now, here's the critical sentence that could change everything. It's been described as a typo, you get to decide, but this is in section 5.5 of the trust document. Settlor reserves any power whatsoever to alter or amend any of the terms or provisions hereof. Any power. What does that mean to you? Well, the court gets to decide what that means, but let's go ahead and substitute the word any for no. Read it again and see how it seems to be drastically different. Settlor reserves no power whatsoever to alter or amend any of the terms or provisions hereof. If the word no were used in the actual trust document on behalf of the husband, remember, he's the only one who had the documents prepared. His wife never saw them. She never signed them. So he's the only one who saw them. He's the only one who signed them. And presumably he's the only one of the two spouses who knew what the legal consequences were. But this clause, if it had used the word no, the husband as the settlor would have had no power to amend anything. That is consistent with an irrevocable trust. The legal issue in the Dahl case is by using the word any, does reserving any power whatsoever to amend. The husband later argues, well, that just gave him powers to amend the trust. It didn't give him power to revoke the trust. And so, according to him and his lawyers, the trust was irrevocable. The wife argues the opposite. This unlimited amendment power goes beyond mere amendment and permits revocation of the trust itself. So we'll see how that litigated. A detailed timeline will help frame the arguments. They're married in 1992. It's an 18-year marriage. They have 2 children of this marriage. In 2006, the husband files for divorce. Between 1992 and 2006, it's not specified, but that's when the husband created what's titled the Irrevocable Trust, had the marital house transferred to the irrevocable trust, including a warranty deed signed by the wife because she was a titled owner of the marital house. In July of 2009, they're close to the divorce trial itself. So this is a hotly litigated, high asset divorce. July 31st, 2009, the wife's lawyers file a complaint against the irrevocable trust. This is a huge legal mistake by the wife's lawyers because the divorce case is about to go to trial. That means they finally realized the divorce trial court had no jurisdiction over the trust because the irrevocable trust is a separate legal entity. It is not the husband as the settlor of the trust. That's a different role. The husband is only a party to the divorce in his personal capacity. He is not litigating the divorce as a settlor or as a named beneficiary of the trust. We're going to be looking at the takeaways. I want to give you one right now. If a divorce involves an irrevocable trust, the trust as a separate legal entity should be joined as soon as possible as a necessary third party because any assets that have been transferred to the trust, it holds title to them, not the husband, not the wife, the trust. And in order for the divorce court to address those assets and address the revocability of the trust itself, it needs to be joined as a necessary party. But because the trust was sued in July of 2009, there are now two parallel litigation tracks. One is the divorce itself that has been being litigated for 3 years at this point, and now new litigation against the irrevocable trust. In July of 2010, so almost a year after the trust is separately sued, which was 3 years after the divorce started, in July of 2010, the divorce decree is entered and signed. And the divorce court held that the trust assets had to be excluded from the divorce because the divorce court had no jurisdiction in the divorce itself over this trust as a separate legal entity, a third party. Then another year passes, August 2011, the trial court hears cross summary judgment motions concerning the trust assets. And in 2011, the trial court grants summary judgment on behalf of the trust. The trust successfully wins at the trial level that it is irrevocable, and the wife has no interest in it because the husband and wife have been divorced for over a year. Remember, the definition of settlor's wife means a status. And as of July of 2010, she's no longer married to the husband as settlor. So the wife in this divorce is no longer a beneficiary. 2011, the trust wins at the trial level. A summary judgment motion means there are no disputed material facts and the court could resolve the issue as a matter of law. It didn't have to go to trial. The trial court separately ordered the wife had no interest in the trust and the divorce court had no access to the trust assets. Both of those decisions are appealed. The divorce judgment is appealed and the summary judgment on behalf of the trust is appealed. And they both end up before the Utah Supreme Court, who submits its decision in August of 2015, 4 more years after summary judgment for the trust, which was a year after the divorce, which was years after the divorce itself was filed. How much does this litigation cost? Hundreds of thousands of dollars. The Utah Supreme Court has both of these separate appeals. The wife needs a legal stroke of luck. The first issue is joinder. We know that the trust was not joined. That was held against the wife. And it was basically the wife and her lawyer's responsibility to recognize, since she's the one who wants assets in the trust to be divided in the divorce, she's the party who has to join the trust as a necessary third party. She and her lawyers indisputably failed to do that. And as a last-ditch effort, had filed this separate litigation against the trust, and she loses because, in part, she loses because the trust was not even included in the divorce itself. Now, this sounds like it should have been solved because the Dahl case was decided by the Utah Supreme Court in 2015. Hasn't everybody learned that lesson? The answer is no. This is a 2024 decision from an intermediate appellate court in Ohio with an even higher asset divorce. This is the Oaks case. And in this high asset divorce, there was an irrevocable trust that held title to the marital house. Now, the marital house during the Oaks marriage was in the wife's name only. They paid $5 million to build this house. The wife opined that the house was no longer worth $5 million, kind of the biggest house on the block theory. Apparently, it was very unique to their preferences and would not sell for $5 million. But during the marriage, for asset protection purposes, the wife transferred title from herself personally to an irrevocable residential trust. And just like the Dahl case, the wife is a beneficiary of that trust by status only. The husband is the trustee in the Oaks case. The husband is the named beneficiary. And as soon as these parties are divorced, the wife will no longer be a beneficiary of their residential trust that has title to the $5 million former marital house. So, what happened here? In the Oaks case, the trial court does the opposite of what the trial court did in Dahl. In Oaks, the trial court ordered the husband to transfer title from the trust back to the wife. That gets reversed on appeal because the trust in Oaks, just like in Dahl, was never joined as a third party. The trial court had no jurisdiction over the trust itself. And in the Oaks case in Ohio, the trust was not a fraudulent transfer. It was created for an asset protection purpose. The wife knew it was created for an asset protection purpose, and the Oaks trust was irrevocable. So they didn't have choice of law issues. It was irrevocable under Ohio law. The divorce was an Ohio divorce, and the Intermediate Appellate Court reversed the holding that the husband transfer the house out of an irrevocable trust back to the wife because the trust is the titled owner and it's an irrevocable trust. The husband wanted to transfer it, he can't. The wife in Oaks loses on appeal, but this is such a high asset divorce, there's a concept called offset. If her interest in the marital house, and it was deemed to be worth approximately $4 million, so that means the wife in the Oaks divorce in Ohio has a $2 million interest approximately in the marital house. They have so many other assets that on remand back to the trial court, she can be awarded $2 million extra of a different asset. They have wine collections in Ohio and France. They have art collections, watch collections, and other valuables that the court ordered them to divide. So she'll simply get more of the wine, more of the art, more of the watches, up to $2 million of what would have been his share because the husband remains a beneficiary of this irrevocable trust, which holds title to the Oaks house in Ohio. This is the Utah Rule of Civil Procedure regarding joinder. And this is one of the main takeaways for everyone. An irrevocable trust is a separate legal entity. If there is formerly marital property that's been transferred to a purportedly irrevocable trust, the trust itself must be joined as a necessary party for the divorce court to even have jurisdiction over the trust, its trustee, and its assets, and even to decide whether the trust remains irrevocable or is somehow revocable and therefore can be reached by the trial court and divided in divorce. So here, a person who is subject to service of process and whose joinder will not deprive the court of jurisdiction over the subject matter shall be joined as a party if his absence, complete relief cannot be accorded among those already parties. That's exactly what's happening in Dahl with the irrevocable trust that includes the Dahl marital house, which is a Utah residence. And it's exactly what happened in Ohio with the Oaks case. The trust holds title to the marital house. It's no longer marital, it is the trust's asset. In order for any divorce court to decide issues about the trust and the assets that were formerly marital, that trust has to be added as a necessary party under a civil procedure rule of whichever state's at issue. This is Utah Rule 19A. Detail what the wife's lawyers did wrong and in Dahl, and to be fair, in the 2024 appellate decision in Oaks, and even higher asset divorce, her lawyers made the exact same mistake. So first, the critical error in the Dahl case was not joining the irrevocable trust from the beginning of the divorce. And the reason why you want to do that is the court has jurisdiction over the trustee, who is the person who acts on behalf of the trust. The divorce court has jurisdiction to decide whether the trust is revocable or irrevocable, and whether the formerly marital assets can be divided. If they can't be divided, there's that concept of offset. Offset was available in the Ohio case because they were such a high asset divorce. They had multiple millions of dollars in other assets that could be additionally awarded to the wife. The critical error here was not joining the irrevocable trust that had the Dahl, Utah marital house in this Nevada trust, and also filing a separate lawsuit against the trust because the wife loses the divorce issues regarding the trust, and she loses her separate lawsuit against the trust at the trial level. She loses both. The division is bad. You need the trust to be part of the divorce case itself, both procedurally and substantively. So that's the first mistake. The timeline of events was her lawyers realized their mistake after discoveries over only weeks before the divorce trial, which means they'd already had to identify pre-trial lists of exhibits and witnesses and all of that. And then at that 11th hour, file a separate lawsuit against the trust. And that takes years to decide. How much more money, hundreds of thousands of dollars more in legal fees, did that cost? The trial court's response, the wife in Dahl loses the divorce issues about the trust, and she loses her separate case against the trust because by the time the trust litigation reaches the summary judgment phase, which is a substantive motion, if either party prevails, then there is no need for a trial. Well, the trust wins because by this time the wife is divorced from the husband in Dahl. She has lost the status as the settlor's wife. The trial court ruled on two issues regarding the trust that were reviewed on appeal by the Utah Supreme Court. We'll see how the Utah Supreme Court handled both of those issues. First, that the trial court had no jurisdiction over the trust as part of the divorce. And then second, was this trust in Dahl really irrevocable? And did the wife really lose her marital interest to those assets? On appeal, the Utah Supreme Court had two cases regarding the Dahls and their trust in front of it. First, the divorce excluding the trust, and second, the wife losing her litigation against the trust. But those were two separate cases. How did the Utah Supreme Court resolve this? The procedural error was resolved because appellate courts may raise the issue of joinder sua sponte, of its own accord. The wife got some legal luck. The Utah Supreme Court did not have to do this. It could do this. It chose to do this. It did not have to. And this resolved the massive mistake by the wife's lawyers, same mistake in Oaks. But on this appeal, the divorce and the separate litigation against the trust are consolidated based on the joinder by the appellate court itself. Here's what the Utah Supreme Court wrote about this, that the wife's counsel's failure to join the trust prevented a complete distribution of the marital estate. That's how significant of an error this is. Both the trust and the divorce cases are before us, and because appellate courts may raise the issue of joinder sua sponte, we hereby consolidate the trust and divorce cases for purposes of appeal, which meant that the summary judgment in favor of the trust was no longer moot, and everything is back in play. Remember, the wife needs to run the table on all four of those issues, including joinder, so she has prevailed in front of the Utah Supreme Court on the joinder issue. Basically, legal luck. The second issue is choice of law. And in Utah, choice of law in a contract or in a trust is generally honored. This irrevocable trust, as it was labeled, expressly chose Nevada as its choice of law. This trust shall be governed by and construed according to the laws of the state of Nevada. There's no ambiguity under its plain meaning. Nevada law applies. Unless, and this is what the Utah Supreme Court was deciding, unless Utah public policy overrides the choice of law provision. Utah generally enforces the choice of law provision, but Utah will not enforce a choice of law provision if it would undermine a strong public policy of Utah itself. Well, Utah has a strong public policy in dividing marital assets equitably. Here, over $2 million of the wife's interest in marital assets is segregated into this irrevocable trust that she is no longer a beneficiary of. Does Utah have a strong public policy interest in attempting to claw that back? And the answer is yes. The Utah Supreme Court held that Utah's public policy in equitably dividing marital assets overrides this choice of law provision in this trust. Now, Nevada law no longer applies. It's Utah law applying. But even under Utah law, this trust may still be irrevocable. And if the trust is irrevocable, the wife in Dahl loses because anyone who contributes property to an irrevocable trust cannot get it back. That's the whole point of irrevocable. Back to this critical sentence. The Utah Supreme Court is analyzing whether this reservation of amendment power expands to revocation of the entire trust. If it does, then the wife prevails. This trust goes from irrevocable to revocable, and now she may be able to claw back those marital assets into the divorce itself. This also could be viewed as a typo, and if it's a typo, the husband loses. If there's any way for this clause to allow the settlor to create a revocation provision and then act on it, then the wife will win. The husband's arguments are that the trust is named irrevocable, it has a clause confirming it's irrevocable, and that the reserved amendment power does not state that it includes a revocation power. We've just looked at that sentence. The wife's arguments were any powers whatsoever would allow the settlor in a multi-step process to amend the trust to give settlor the power to revoke it and then to subsequently act on that newly amended revocation power. The plain meaning of any means all provisions, including irrevocability. Wife wins. So under the Utah Uniform Trust Code, section 75-7-605, any unrestricted power to amend extends to revoking the trust itself, and that's how the husband loses. The Utah Supreme Court relies on a 2003 case called Flake, where this amendment power was interpreted as including the revocation power. The Utah Supreme Court relied on similar reasoning from states like Illinois, Massachusetts, Nevada, and New Jersey. So you can add Utah to that list. If the settlor retains broad amendment powers, it's interpreted in these states to include the power to revoke, which would transform an irrevocable trust back to revocable. And that is a game changer. The wife wins in front of the Utah Supreme Court under an indirect revocation theory. First, exercise the amendment power and notify beneficiaries. Then, delete the irrevocability clause. Next, insert a revocation power and then revoke the trust. That is the multi-step process that the Utah Supreme Court held the husband as the settlor could do with that broad any reservation of amendment power. And this is the key footnote. So if you're reading the entire case, have a look at footnote 13. This is the Utah Supreme Court. Where we construe the trust as irrevocable, it would create a serious conflict between trust law and divorce law in Utah. The question of whether a spouse could create an irrevocable trust in which he placed marital property, thereby frustrating the equitable distribution of property in the event of divorce, is not before us in this case. You know why? Because they held that this trust was revocable. But if they had to hold that this trust was irrevocable, the husband would have succeeded removing $2 million from the wife's division of assets, meaning he would be getting $2 million more than he would have had this trust never been created. Now, the final sentence of this footnote 13 is really important. The Utah Supreme Court in 2015 is saying, we bring the potential pitfalls to the legislature's attention. The legislature has done nothing on this. The legislature has not resolved the issue, which means this can still happen in a divorce if someone makes an irrevocable trust truly irrevocable without that possible typo using the word no instead of any. Drafting for actual irrevocability would be avoid any powers of amendment. Also, if there are powers of amendment, be specific and limit them. Consistency throughout the document, because in the Dahl Trust, we had that section 5.5 with that broad amendment power, which was inconsistent, contradicted the title of irrevocable trust, and then the confirmation in the trust itself that the intention of the settlor was to make this irrevocable. Finally, substance controls, not labels. Issue 4, trust creation. Who is the settlor? In the trust itself, the husband is the only named settlor, but he's not the only one who contributed property. The legal question is, anyone who contributes property to a trust who doesn't sign and isn't separately named as the settlor, does the contribution of property to help fund the trust make you a settlor? Because if the trust becomes revocable, which we know it has, a settlor can remove property transferred to the trust to fund the trust. If the wife in the Dahl case is a settlor, she can claw back that $2 million of marital property, her interest in marital property, the house and the business, so that it can be divided and awarded to her alone in the divorce. Husband argues there's only one settlor because he is the only one named. He is named as the sole settlor of this irrevocable family trust. The wife, she agrees, yes, I was not named as a settlor. She also points out she never saw the trust documents. Of course, she didn't sign them if she never saw them. And she was not aware that she might lose her interest in the assets she transferred to the trust because she had no idea she was only a beneficiary as a status and not as a named beneficiary. But the key fact here is that the wife indisputably contributed over $2 million of her marital interest in property and some separate property. She indisputably contributed marital assets to the trust, including by signing a warranty deed to transfer the marital house along with the husband. In addition, there was no forfeiture evidence. The wife didn't knowingly forfeit her status as settlor. She had no intention to give up her rights to the property she transferred to the trust because she was unaware that she was not named as a beneficiary, surviving any possible divorce. And then we have Utah Code Section 75-7-1031K, defining a settlor as a person who creates or contributes property to the trust. And that is how the wife in the Dahl case was held to be a settlor. And as a settlor, she can revoke her contribution to the trust, which solves the problem for her in this divorce. Utah Code 75-7-6052 governs trusts with multiple settlors because that's the next issue. Each settlor may revoke or amend the trust only as to the portion of property they contributed. Well, that's all the wife needs to do in this divorce anyway. She has a marital interest in the $2 million she contributed. Husband would keep his marital interest, and if he wants to keep it in the trust, he can. But she can revoke her contribution, get it back, and be awarded it entirely. These were our 4 issues. The wife wins on each one. On joinder, legal luck, pure legal luck. The appellate courts at any level can sua sponte of its own accord add a necessary third party under the joinder rules. And that's what happens in front of the Utah Supreme Court, that the irrevocable trust gets joined as a necessary third party. On remand, now the divorce court has jurisdiction over it based on the other decisions by the Utah Supreme Court. So second, this trust is governed by Utah law because Utah public policy would be frustrated if Nevada law was applied. Because Utah law is applied, this trust is revocable under the Utah Supreme Court's interpretation of that unlimited amendment power. And then finally, under Utah law, the wife is a trust settlor simply because she contributed $2 million of her property to help fund the trust. And this is how the Utah Supreme Court described its holdings. We construe the trust agreement according to Utah law based on Utah's longstanding public policy interest in the equitable distribution of marital assets upon divorce. Next, we conclude that the husband reserved an unrestricted power to amend the trust. Under Utah law, that unrestricted power gave the husband the ability to revoke the trust, thereby rendering the trust revocable through that indirect revocability theory that we looked at. Because the wife contributed marital property, $2 million, she retains the status of settlor and may revoke the trust as to her contribution of both her separate property and her interest in any marital assets. Now, the court also points out offset, that the husband, if he wants to keep all the marital assets in the trust that he tried to make irrevocable, he can only do that if he can offset. If this family has a separate $2 million in marital assets, or he himself has separate $2 million in assets to compensate the wife, to offset what remains in the trust. That is the solution that happened in the Ohio case we looked at. That trust was irrevocable. The marital house was irrevocably owned by the irrevocable trust. So the wife had no longer had a marital interest in a $4 million house that they paid $5 million to build. But because they had so many other assets, offset was not a problem at all. And the trust and the husband remaining a beneficiary of that irrevocable trust in the Ohio case meant the wife would get an additional $2 million of other assets. It would be an unequal division of what remained marital assets because of what was transferred to the irrevocable trust. And then finally, the Utah Supreme Court remands the trust case, consolidated with the divorce case, to the divorce court to equitably distribute those trust assets that are marital property that the wife chooses to remove. The takeaways are significant for this irrevocable trust case in divorce. The first takeaway is this: anyone considering transferring a marital residence or any other marital property into a trust for asset protection, estate planning, any other legitimate reason, Each spouse needs separate legal representation. Each spouse needs to see the trust documents and to see how you are named as a beneficiary. Are you a permanent beneficiary? Or even if you are named as a beneficiary, does the other spouse retain the sole power to change beneficiaries? This is a critical issue that is going to be dormant unless and until a family that has transferred marital assets into an irrevocable trust. You can do the same thing with community property. If it's structured like this, divorce changes who the spouse is. This is the biggest takeaway from the Dahl irrevocable to revocable divorce trust case. Exactly what the husband in Dahl tried to do, the husband in the Ohio case we looked at succeeded. He succeeded as far as the trust went, but because they were such an even higher asset divorce, offset was available. So the wife in the Ohio case was not financially disadvantaged by the irrevocable trust. That is the opposite of what occurred here in the Dahl case in Utah at the trial level. The wife lost. The divorce could not consider the trust assets, and she lost the trust case, the separate litigation against the trust, because the trial court ruled that Nevada law applied, and under Nevada law, the trust was irrevocable. The wife wins in front of the Utah Supreme Court only because she was able to run the table on all four issues. But someone could be looking at the Dahl case and looking at the Ohio case, which was Oaks, and seek to avoid the mistakes made here in the Utah case. And what would that be? Well, how it happened in Ohio, which is simply asset protection. In the Ohio case, both spouses testified that they transferred significant assets to an irrevocable trust to protect them in case anyone sued them for any reason, for example. That's a valid purpose to create a trust. It was not a fraudulent transfer. In the Ohio case, the wife was even aware of the asset protection purpose. The Ohio opinion doesn't talk about whether the wife knew her beneficiary status would terminate upon divorce. Marital assets go into an irrevocable trust in the Ohio case and in the Utah case, and only one spouse in each of them, it's the husband, but it's equal opportunity. In each case, it's the husband who's the only permanent beneficiary between husband and wife. The wives in each of those cases lose their beneficiary status as soon as they're divorced because they are not named. It's simply husband's wife is the definition. The takeaway is any spouse transferring property to an irrevocable trust, whether you're initiating it or your spouse is, each spouse needs separate legal representation. You each need a lawyer licensed in your jurisdiction, or if necessary, the jurisdiction for choice of law purposes of the trust, to explain to you what you get, what the benefit of the bargain. For example, if you are transferring $1 million of your marital interest, $2 million of your marital interest, like in the Utah case, what do you get for that? Are you a permanent beneficiary in your lifetime, meaning no one can revoke your beneficiary status? You are actually named and you're not merely defined as whoever is the other spouse's spouse, because that leads to a few years later, a divorce where you would no longer satisfy that definition. That's the biggest takeaway of the Dahl case. We have additional takeaways for divorce lawyers. And the first is, you're not going to be surprised, it's just like our first issue. Investigate trusts as soon as possible and join the trust as a party early. An irrevocable trust needs to be joined. Now, a revocable trust is totally different. A revocable trust means one or both spouses have access to the property owned by the trust. The divorce court has jurisdiction over these spouses, so that property can be divided even without joining a revocable trust as a party. But if the trust purports to be irrevocable, on its face, it has separate legal status. Any marital property transferred into it is not marital. It's owned by a separate party, and the person who needs to be served with service of process is the trustee who acts on behalf of the trust. Trusts need to be investigated, and an irrevocable trust needs to be joined during the time period of discovery. That's the mandatory period. It has a start and has an end when financial information and other documents must be exchanged. You need the trust to be part of discovery so that in case the other spouse, who's only participant in the divorce personally, declines to respond on behalf of the trust. Irrevocable trusts may not be irrevocable. That's another reason to make sure that issue is looked at. And then identifying all settlors. Under common law, any person contributing assets to a trust is a settlor, even if they don't sign anything. Does your state follow the common law by statute, or does your state have a statute that is the opposite? That will be relevant in your jurisdiction. Additional takeaways for wealth managers, financial advisors, estate planners, and lawyers. Irrevocable may be revocable. Any estate plan that includes an irrevocable trust needs a lawyer to review it to make sure there are no contradictory terms, which is what occurred here in the Utah case of Dahl. Unrestricted amendment power, by definition, can lead to that indirect revocation, and that's why the phrase was interpreted against the husband and in favor of the wife here in the Dahl case for Utah. Property contributors as settlors identify all settlors because a settlor has the ability to revoke their contribution to a revocable trust. Choice of law provisions. Why was Nevada chosen as the choice of law provision for the Dahl Irrevocable Family Trust? Because Nevada is a state known for its statutes that favor irrevocability of irrevocable trusts. And finally, 2 issues regarding the trust. Join an irrevocable trust as a necessary third party and look for the opportunities of offset. Even if, like in the Ohio case, the irrevocable trust is not fraudulent, it is not revocable for any reason, and the marital house built for $5 million, valued around $4 million in the Ohio divorce, that Oaks case, that was lost to the wife, but because they had so many other valuable assets, offset, which is simply she gets more of what's left to compensate her for her marital interest in what ended up in an irrevocable trust. Those are the 2 final takeaways. Thank you for joining us. Stay tuned for a preview of our next episode. What happens when a beloved pet dies 2 years before its owner and an $80,000 pet trust vanishes into legal limbo because of one missing clause? In 2023, the Massachusetts Supreme Judicial Court had to answer this exact question in the Jablonski case. Here's the problem. If Licorice the Cocker Spaniel predeceased her owner, the testamentary trust would lapse under Massachusetts law. And the will's residuary clause created a circular reference, pouring failed gifts back into the invalidated trust. But buried in Article 5 of that pet trust was a charitable remainder provision. With language so ambiguous about whether it required the pet's survival, it would take Massachusetts' highest court to determine whether $80,000 goes to charity or to probate for 4 fighting heirs, nieces and nephews. I'm Kelly Lise Murray, and this is Wealth Litigated, delivering all the drama of true crime without the blood. We break down actual court cases that impact your professional practice and your clients' wealth outcomes. In episode 108, Pet Trust Gone Wrong, Trouble Transferring $25 million, we examine how 3 separate pet trusts expose critical estate planning failures affecting pets and people, explore legal battles from Massachusetts, Manhattan, and Milan, Italy, featuring a $12 million Maltese and a $13 million stray cat, and analyze the court decisions detailing what went wrong that wealth managers, financial advisors, estate planners, and pet owners should avoid before preparing pet trusts. Join us to see how it litigated.
This is Wealth Litigated, where the real courtroom battles we analyze today are your roadmap to stronger asset protection and better wealth outcomes. Follow us on your favorite podcast platform or subscribe on YouTube so you never miss a weekly episode. Questions or cases? Visit wealthlitigated.com/questions. This show is for informational and educational purposes only and does not constitute legal, tax, or financial advice. No attorney-client relationship is formed. Consult a qualified professional for advice specific to your situation and jurisdiction. Wealth Litigated is now adjourned.